Hello, 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 everybody. Hello. Yes, I'm early. I'm early tonight. I'm early, but I'm so tired. I had to come on. Yes, happy Sunday. Hello, hello, everybody. Hello, happy Sunday. Hello. Yes, I'm on a little bit early, but it's well, right. It's 7 if we didn't change the clock. That's a good point. Yes, I felt like I needed to come on before it got much later. So, welcome on in, everybody. Hello, hello. Oh, from Australia. Good to see you. Welcome. Welcome on in, everybody. Good to see you. Hope your weekend has been going well. Oh, thank you so much, Martha. I appreciate that. Yeah, I'm on just a little bit early tonight, but I figured most people wouldn't mind. So, yes, I've got a little bit of the glitter going on. A little glitter going on. Oh, from Texas. Well, hello, hello. Yes, I'm very early too, Mia, so no problem. Yes, I've got lots of updates tonight, but also I wanted to spend a little bit of time talking about the 14th Amendment. Just a little bit. Oh, your cat too. Oh, we love that. Love that. Yes, the Navy nails for tonight. So I will be talking about the 14th Amendment after all of our updates. So I wanted to give everyone kind of a heads up on that. Hello from Florida. Hello. Yes, I've been doing a little bit, Thomas, a little bit of picking and singing. Not very good. But, it's good enough for me as long as no one hears me. It seems to be okay. Oh, from Texas also. Well, there's a lot of land there in Texas, so a lot of land for sure. In Mexico, hello, in Virginia, Michigan, Minnesota. Oh, I hope you're staying warm up there. My goodness, my goodness. Oh, thank you kindly. That's so sweet of you to say, Thomas. I appreciate it. Utah, Georgia. Wow. Tennessee. Oh, love it, love it. Southern California, Santa Monica. Oh, very nice. Wow. Eastern Washington. Oh my gosh. Ooh, Idaho. Woohoo. Oh my gosh. You're from all over the place, everybody. Well, welcome. Welcome on in. Good to see everybody. Very good to see everyone. Maryland, Florida, Illinois. Okay. Wow. Lots of California. Montana. Very nice. My goodness. And Indiana. All over the place. Well, welcome, everybody. Good to see you all. Thanks for coming tonight. It's good to see. Ooh, West Hollywood. Very nice. Very fun. Oregon. Now, I would love to go to Oregon sometime. I've never been to Oregon, but I've heard it's gorgeous. I would love to go there someday. Yes. Hey, from Earth. You got it, Kristen. Earth it is. Oh, from Austin, love that. Yes, good to see you too as well. Good to see you as well, yes. Yes, and from London. Hello, Deborah. Always wonderful to see you. Thanks for coming. Hello, Stephen. Wow, everybody all over the place. Love that. Love that. Tennessee, oh my goodness. Eastman's on 60 Minutes. Oh, well, that should be interesting. For those of you that hung out with me on Friday, we were going to watch a hearing, one of Eastman's hearing, but there were some suspicious things going on with the recording. I have gone back and viewed that, so I'm trying to figure out how I can do a live safely with that. Hello from Minnesota. Hello, BC. Always a pleasure. Ooh, Colorado. Very nice. Hopefully you're staying warm. I did. I really did. I laughed so hard. I laughed harder than I should have, but I couldn't help myself. Oh my gosh, I couldn't. Yes, Friday. Oh my gosh, yes. Well, it's good to have fun once in a while, right? Yes, well, Hitch, I've got lots of updates tonight. So I've got orders out of I've got the new gag order out of the New York civil case to go through. I have a couple of motions filed by the government in DC and Florida, and then I've also got some defendant motions too. So I think we all laughed pretty hard Friday. I agree. I agree. Oh my gosh. Yes, live to tell the tale. I love that. Oh my gosh. Oh, thank you. Thank you so much. Yes, Abuela, I took a look and just to make sure, and it looked like there was just a screen going on behind it. So I think I am going to try to do a live showing that video actually. I figured out which parts I need to fast forward through. So I think I'll be able to do a modified version. Oh my goodness, that was funny. Yes. I think it'll be fun. So I'm gonna work on that for sure. I think it's good to go through Eastman stuff. It's a fascinating hearing. So, well, welcome in. Yes, everybody, we've got lots of interesting things going on in the world. So let me, as you're all coming in, let me just get my calendar out. Here we go. Nope, I'm way early. I'm very early. So, of course, Timmy, I'm happy to help. Happy to be here. Yes, 60 minutes. I'll have to go back and take a look at that. Oh my goodness. No, he didn't help his case at all. He really didn't. But I don't think we were really expecting him to, for sure. But, it's always fun to watch them try to get through the situation. I find that fascinating because of the time change. Yeah, I think everything's a little bit off. But we do have a busy week ahead of us, everybody. We've got Trump testifying on Monday. We've got Ivanka testifying on Wednesday. We've got DC motions coming in as well. But really, the big piece will, of course, be Mr. Trump testifying on Monday. That'll be the big moment. Lots going on with that. I don't think any of his testimony will be surprising, for sure, but I think it will be interesting to watch. We did finish up our 14th Amendment cases this last week, so we're kind of waiting on the judge's opinions on those. We'll see that. Yeah, I'm thinking 2 days. That sounds about right. 2 days. I wouldn't think it'd be much more than that. And I think that's why they scheduled Ivanka for Wednesday, too, to kind of keep everything going. So I think that sounds about right, everybody. So before I dig too much into our documents, because I am so early, I had a question I wanted to ask everybody. Oh yeah, no, these are just regular press-on nails. Yep, this is just one of my favorite sets, so I wear it a lot. Yep, I do play guitar, so I need to be able to remove them easily and put them back on. So it'd probably be easier if I just had nails that stayed on longer, but I just can't give up playing my guitar. So now I did have something coming up this week, everybody. I kind of wanted to give you a heads up on the Supreme Court. The U.S. Supreme Court on Friday had agreed to hear two cases, two writs of cert went up, and this one is the first one. And I just wanted to give you a peek here. This has to do with bump stocks that they have classified as these kinds of Gs under the National Firearms Act. This was changed, of course, just a couple of years ago. So this case has been granted cert. So the U.S. Supreme Court will be listening to this case just as to issue one that they've raised here. I did want to go through this case with everybody. Again, there are two cases. I thought I would do a live just explaining the outline of what the issue is going on in the case. I thought that would be something really interesting. I won't be doing that tonight, but I'm just kind of giving you a little bit of a preview here on this because it is a pretty big deal. Oh my goodness, Kristen. Oh, thank you. Thank you so much. So this, again, was something that the U.S. Supreme Court granted cert on. Yes, nope, only a little bit. Yes, so that's a great question, Chris. So these bump stocks, again, I'm not a specialist by any means. I understand them within the context of all of the cases, but they are something that you can attach onto a weapon that makes it turn from a semi-automatic into an automatic. So the number of rounds that can be gone through at one time. So this case, again, is just another question of how far the cases are when it comes to what the Second Amendment covers, what they don't cover. So this is about a statute that was signed by Trump and changing these kinds of weapons when you add a bump stock into a machine gun, which are not protected by the Second Amendment. So this case is asking that question, is that statute violating the Second Amendment? So yes, exactly, Scott. Yep, this was exactly it. So that's a pretty big deal. Now, the reason I bring it up is because we do have a case coming up in front of the U.S. Supreme Court this week on Tuesday, which is a Second Amendment case. And the Second Amendment case has to do with whether or not, this case that's coming up Tuesday, has to do with whether or not if you have a domestic violence conviction, if you can have your guns removed. So the petitioners are contesting that. So that case will be the one that will be heard in front of the Supreme Court this week on Tuesday. I thought I had grabbed my brief, but just one moment. Let me go grab the case citation. So this is the petition for cert here. In order for the U.S. Supreme Court to hear any case, you have to petition them on a writ of certiorari. So this is the petition, and it's U.S. v. Rahimi, and the U.S. Supreme Court will be hearing arguments this week for anyone who is interested. I haven't spent a lot of time going through this case on any of my lives, but this week I do really want to focus on what's going on with SCOTUS. So I will have several posts coming up just giving brief overviews of these cases and also explaining, we have two huge cases, the McDonald case and the Heller case. Of course, Bruen was decided just a couple years ago, but those are the big cases that have to do with the Second Amendment. So I'll probably be doing just a few posts to kind of update everybody to keep you aware. Oral arguments, again, are going Tuesday for SCOTUS, so it's kind of a big week when it comes to the Second Amendment. Yes, they've got arguments live. And they do such a great job over there at SCOTUS blog. Oh my gosh, they do such an amazing job. Absolutely. So it's a really interesting question being presented again. I think a lot of people don't realize that, none of our amendments are absolute, and we've got some restrictions. It's just what extent the restrictions can be. So the Rahimi case will be heard in front of SCOTUS on Tuesday. Amy, yes. Oh my goodness. Yes. So she's exceptional. That whole team there does an amazing job. But I just wanted to remind everybody that is coming up this week. There have been some interesting cases in front of SCOTUS since they started again. The first week in October they come back, but nothing at this caliber yet. So this is pretty significant, this particular case coming up. So just wanted to remind everybody, if you are interested, I will be doing some posts this week on this issue. So friendly reminder on that. And then that takes us back here to the calendar. So tonight, everybody, I know I'm early, but I'm also tired. Is anybody else tired? I'm a bit tired. So I had to come on a little bit early. But I will be taking us through a few orders. So tonight we've got a couple of orders out of Florida. We have a paperless order. I did touch on this a little bit last time, but I have a couple of orders or a couple of motions that came out of Florida this week. Then we also have the new gag order that was set up out of the New York civil case. Yes, raise your hand if you're tired. I know, I don't know. Maybe it's because the daylight time has changed, but whoo, I'm emotionally drained. I hear that too. So I've got the supplemental limited gag order out of the New York case. So we'll be going over that. And then I also have, this is kind of my preview here, the government's opposition to defendant's motion for an extension of time to file pretrial motions related to discovery and subpoenas. I went through the defendant's motion last week, and so this is the government's response. This is the District of Columbia case. So I have that one, and then out of District of Columbia, we also have the defendant's response to prosecution's motion for leave to file an oversized brief, which is just ridiculous, but you know, whatever, to each their own. So I've got these two out of DC to go through. And then here is the motion out of Florida. This is the government's motion for a notice and disclosure regarding advice of counsel defense. Now, if you'll remember, we had an advice of counsel defense motion set out before. So here's another one now on the books. And of course, all of that is coming in after we have this paperless order from the Judge Cannon, in the Florida case regarding filing things. So I thought that was interesting. So I will be going through that, but I also I have one more thing here. So I had a couple of things. One was, now a lot of people have been asking about Judge Cannon in Florida. I have the opinion here that reversed her in her previous ruling on the warrant issue in the special master. I wanted to know if this is something that you would all be interested in me going over on a live or just a post on it. But this kind of explains how she was overruled and why she was overruled. I wasn't sure what the interest. I'll do on a live. Okay, on a live. Oh, absolutely, I can do it. We will have time this week to kind of go through a few different things, but I thought it was interesting. We can kind of talk about what their ruling was, where she had kind of messed up, why they felt that she was wrong and reversed her. So I thought that would be very interesting. Okay. Well, I think what I'll probably do then is I'll probably do it on a live, but then also do a little post on it as well. Just making a note, everybody, real quick. I wanted to ask, because I think a lot of people are concerned about Judge Cannon, and I thought that might help people understand what was going on there. The other thing I had to, just real quick also. Oh, yes. Oh, yeah, of course, Cozy. I will be taking it pretty easy. These are kind of shorter orders. So this is another one I had. This is the people of the state of New York versus Steve Bannon. I wasn't sure if everyone was aware we had a money laundering case going on in New York with Steve Bannon. So that was something too that I wanted to go through. So that's kind of on my docket for this week. Yes. Oh yeah, absolutely. So, yeah, I know it's shocking. So I will probably be going through this indictment too, again, sometime this week. This is just a really good week to do it because the docket's relatively light. I don't expect to see a lot of motions coming in. Heaven to Betsy. Yeah. Another one. So we have Steve Bannon here. And then, let's see. And then, of course, we talked about this last week. I did want to go through the TikTok v. Trump case. So that's also, so I'm just kind of forecasting into this next week on what I'm hoping to do for topics for these lives coming up. Oh, really? On Thursday? Oh, that's good to know. I'll need to add them to my calendar. Yes. Ivanka. Yeah, she'll be back. That'll be very interesting. So this is also then coming up. So that's kind of what I've got on my own personal docket. And then, of course, if we've got time, I do have this case involving Gaetz and Marjorie Taylor Greene and a lawsuit regarding them not being able to speak at a particular site. So I do have that case too. A lot of people had requested that. So that's also on my list. So those are kind of what I'm looking at doing this week, kind of in addition to what our regular discussions will be, of course, which will be updating everything going on with the Trump cases. So I wonder if the court has access to... Oh, could be. I think so. When do you do sub only? Okay, Hitch, I'm glad you asked. So I wanted to talk about that too for a minute. So I think what I have figured out is that, did Ivanka get a babysitter? Oh my gosh. Oh, best comment ever. That's so funny. Oh my gosh, that's funny. Okay. So I think what I've decided... What I've decided is that instead of doing 2 lives in one day, I think I will just take one full live session to just do the sub only, just to save my voice. I think the last time I had just run out of voice. So what I wanted to do was do it on the Wednesday live at 7 p.m. And this is Central. And then rather than doing a regular live at 7 and then doing a second one at 10, I will just do the sub only live. So I'll just have my sub only chat. Of course, anyone can come and listen. It's just the comments will be subscribers only, just as a thank you for the support and to kind of give my moderators a bit of a break. So all my moderators are, of course, welcome to join. You're all approved to come in and join my sub only, of course, as again, another thank you for all your hard work. But I think I'll just leave Wednesdays to sub chat only, and all the rest of the days it'll be plenty open for everybody, but Wednesdays will be sub chat only rather than doing 2 in one night. And then that way I can make sure that I've got plenty of voice for it. So you certainly, again, do not need to subscribe whatsoever. This is just my way of kind of saying thank you to those that are subscribing. So we'll have a bit of a more quiet, more laid back sub chat only. So that will be Wednesday this week. You weren't approved, Deborah. No, I'm so glad you told me. I went in, I thought, and had approved everyone. For some reason, Deborah, you just seem to miss out on everything. I got to go back in. I'll get you on there for this next one. You got it. Oh, you too, Desert. Okay, everybody. Okay. I will go back in, everybody, all my moderators, and double check. Make sure. I thought I had turned all of you on, but I will turn you all on tonight. So you can, yes, I do. I'm thankful so much to my moderators, but it's kind of exhausting. So it's nice to have a little break for them too, to be able to just hang out. Yes, VC, wonderful. Thank you so much. Yes, all of them. But of course, you do not need to subscribe. This is just a thank you. We'll just do it Wednesdays. But all the rest of the week will be open, regular chats, just for everything else, of course, and we'll be doing updates as we go on. I'm waiting on a couple of big briefs that should be coming in here. So those I'll probably be going over tomorrow once those briefs come down. So, yes. So let me go ahead, everybody, and start diving in then. We've got some great paperwork for tonight. Paperwork. I love paperwork. But let's start in New York, everybody. That's kind of the talk of the town. Yes, absolutely. Do we know why he ran out of the courtroom? I think he was frustrated. With what happened when the judge had him testify. So that's what I think happened. So real quick, everybody, let me remind you, we've got the New York civil case going on here. For anyone who is interested, all of the evidence is available online. You can go publicly into the court file there and pull up any of the exhibits, any of the transcripts that you're interested in, anything that you would like to know. Oh my gosh, yes, of course. Thank you so much, new subscribers. You, again, certainly don't have to. But yes, I know paperwork, it's fun. But all of this is available online. I've gone through several of the exhibits already that I found particularly interesting. I do actually have a deposition of Michael Cohen, and I'm thinking I may do that deposition on the sub-only chat night. So I'm thinking that should be kind of a fun thing we can talk about. So I think that'll be our topic. Oh, thank you. Thank you so much, Hitch. I appreciate that. But all of this, again, is available online through the New York courts. We did have a modified gag order that was issued then on Friday. So I'll go ahead and take you through this. Let me get my sticky notes up and going here, so everyone knows what I'm going to be talking about. Or so I can remember too. Will you invite Legal Dad to any of your lives? Oh, sure. Absolutely. Absolutely I will. I'm not sure if I can remember. I've hopped on with them a couple of times, and I'm hoping I had invited them when I was on, but come to think of it, I'm not sure if I directly invited them. I probably should do that though. Fantastic group of fellas. Always fun to hang out with them. So I will absolutely get some of that set up for sure. So I'm writing out my sticky note here, New York civil case, and then this is the gag order update. Gag update. Let me make sure I write the words out so I don't get into trouble. Everybody, yikes. Yikes. All right. So here we go. New York civil case. This is terrible writing tonight, everybody. I'm sorry. I think the daylight time has really gotten to me for some reason this year. All right, here we go, everybody. So this was issued Judge Engeron then on the 3rd supplemental limited gag order. On October 3rd of 2023, after defendant Donald J. Trump posted to his social media account an untrue, disparaging, and personally identifying post about my principal law clerk, I imposed on all parties to this action a very limited gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff, emphasizing quite clearly that personal attacks on members of my court staff are unacceptable, inappropriate, and I will not tolerate them under any circumstances. I further made clear that failure to abide by this directive will result in serious sanctions. End quote. On October 20th of 2023, upon learning that Donald J. Trump failed to remove the post from one of his campaign websites for a total of 17 days, I imposed a fine of $5,000 against Donald J. Trump for violating the gag order. On October 25th, after conducting a brief hearing, I concluded that Trump had intentionally violated my gag order by stating, sorry, I was thrown off by the gaggle, by stating to a gaggle of reporters outside of the courtroom the following statement in reference to my principal law clerk. This judge is a very partisan judge with a person who's very partisan sitting alongside him, perhaps even more partisan than he is, and fined him an additional $10,000. I imposed the gag order only upon the parties operating under the assumption that such a gag order would be unnecessary upon the attorneys, who were officers of the court. Over the past week, defendants' principal attorneys, namely Christopher Kais, admitted pro hoc vice, Clifford Robert, and Alina Haba, have made on the record repeated inappropriate remarks about my principal law clerk, falsely accusing her of bias against them and of improperly influencing the ongoing bench trial. Defendants' attorneys have made long speeches alleging that it is improper for a judge to consult with a law clerk during ongoing proceedings, and that the passing of notes from a judge to a law clerk or vice versa constitutes an improper appearance of impropriety in this case. These arguments have no basis. Pursuant to 22 New York Code 100.3 sub B sub 6 sub 6 sub C, a judge may consult with court personnel whose function is to aid the judge in carrying out the judge's adjudicative responsibilities, or with other judges. This is precisely the role of a principal law clerk in the New York State courts. Moreover, ethics advisory opinions have further emphasized that the relationship between a judge and his or her law clerk is one of particular trust and confidence. Although a judge and his or her law clerk are, of course, not partners, the two engage in a kind of professional interchange that might be found between longtime colleagues in a law firm. As I have stated on the record, seemingly to no avail, my law clerks are public servants who are performing their jobs in a manner in which I request. This includes providing legal authority and opinions as well as responding to questions I pose to them. Plainly, defendants are not entitled to the confidential communications amongst me and my court staff, who are hired specifically to aid me in carrying out my adjudicative responsibilities. Nor are they entitled to make their record and have nor are they entitled to continue referencing my staff in the record. Defendants' attorneys have had ample opportunity to make the record, and they have at length. Indeed, I will assist them by repeating here that I will continue to consult with my staff, as is my unfettered right, throughout the remainder of the trial. Accordingly, defendants' records is now fully preserved for the duration of the proceedings. Defendants' attorneys may refer back to this blanket statement in their appeal as they deem appropriate. Wow, this judge is mad. Defendants may reference my staff as is appropriate to ask about scheduling issues or the management of the trial, which is an integral part of their jobs. What they may not do is to make any further statements about internal and confidential communications, be it conversations, note passing, or anything similar between me and my staff. Defendants' First Amendment arguments in opposition to the imposition are wholly unpersuasive. This gag order is as narrowly tailored as possible to accomplish its purpose, which is to protect the safety of my staff and promote the orderly progression of this trial. As I have made clear as the judge in this case and the trier of fact, the gag order does not apply to me. However, I will not tolerate under any circumstances remarks about my court staff. The threat of and actual violence resulting from heated political rhetoric is well documented. Since the commencement of this bench trial, my chambers have been inundated by hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages. The First Amendment right of the defendants and their attorneys to comment on my staff is far and away outweighed by the need to protect them from threats and physical harm. Yikes. Thus, for the reasons stated herein, I hereby order that all counsel are prohibited from making any public statements in or out of court that refer to any confidential communications in any form between my staff and me. Failure to abide by this directive shall result in serious sanctions. Yikes. Boy, he's mad. Yeah, this judge is mad. He's had it. He's not playing anymore. He's not messing around. So this was a supplemental order done on Friday in the New York civil case for Will Smith. Oh, my goodness. I agree. He certainly does have every right to. This level of safety is absolutely essential in this case. Okay, everybody. So let's hop over then into Florida. So here we go. Florida, of course, is the case where we've got the classified documents. We have 3 defendants in the Florida case going on. We've got questions about the Classified Information Procedure Acts and so on. The latest paperless order that came down from Judge Cannon had to do with the government had filed notice to her that Trump had asked for an extension of time in the DC trial. So he filed a motion telling the judge that in Florida. She came back with this order stating the parties are hereby reminded of the requirements of Local Rule 7.8 on the notices of supplemental authority, except as authorized by the court order. The substantive content of any such notice or response may not exceed 200 words, which is very interesting, and may not be used as a surreply absent leave of court. Future non-compliant notices or unauthorized filings will be stricken without further notice, signed by Judge Cannon. So she basically just said, hey, if you guys are going to file anything, you need to follow the rules and don't give me a whole bunch of extraneous stuff. I don't have time for it. Is this the paperless order so it cannot be appealed? So I'm not sure that it's a paperless order specifically so that it can't be appealed. I'm not sure if that's the intent or if it's because she's because she's busy, I guess. I don't know exactly. I'm not sure if it's like customary for her to have so many paperless orders. When I look at Judge Chutkan's case and kind of compare the two, Judge Cannon does have more paperless orders than Judge Chutkan, but also the case has been going on longer in Florida than the DC case. So I am uncertain right now why she's doing so many paperless orders. Usually judges will do that when they just don't have time to sit down and write a full order out. One of the big things about that then is that, of course, it is harder to appeal a paperless order like this, but you also need to make sure you have an appealable issue in order to appeal it also. So if you don't, like something like this is not an appealable issue, but if you had an appealable issue and it was a paperless order, then you would have to ask that question. Is it paperless so that they can't appeal it? But technically you could appeal a paperless order. It's just much more difficult. All right, so then that takes us to the government's motion for notice and disclosures regarding advice of counsel defense. So right after that paperless order was issued, kind of saying, hey, make sure that your stuff is relevant and within the guidelines. The government did file this on the 3rd. So let me get another sticky note out here and take you through this order. So this is U.S. v. Trump, and this is the Florida case. Florida. And the one that we're looking at here is the government's motion. Government's motion on advice of counsel defense. Now, we've been talking back and forth about this advice of counsel defense, how the defendants are saying, we shouldn't have to say anything about our defense. Meanwhile, the government is saying, well, if you have an affirmative defense, you have to plead it, just like all affirmative defenses. You're no different. So there's been this argument going back and forth. All right, so this one again is the government's motion. Make it fun. I don't know about that. Oh my gosh. All right, let me get lined up here, everybody. I feel like I'm a little bit out of frame. Let me see here. Can move back over. There we go. All right, should be back in frame better here. There we go. All right, government's motion for notice and disclosures regarding advice of counsel defense. Now, this is the government. Thank you, Amanda. Yes, I agree. I think I was a little bit out of frame there. So this is the government's motion, so we don't need our red pen. So here we go. The government moves for pretrial notice of defendant Donald J. Trump's intent to assert an advice of counsel defense and disclosure of any discovery related to it. Now we have the first footnote, footnote 1. Defendants Walty Nada and Carlos de Oliveira have given no indication that they intend to rely on advice of counsel defense. So in the Florida case, we have 3 separate defendants here, but he's only asking about Trump because these guys haven't made any comments regarding using this kind of a defense. So Trump has made comments. Now I'm going to take a quick tea break, everybody. One moment, please. All right, here we go. Defendant Trump, hereafter defendant, has claimed publicly that he believes the law allows him to quote, do what I want. Here's a footnote here. Interview with Megyn Kelly. Oh my goodness. Oh dear. This is starting off tough here. With classified documents. And further, that he was told legal precedent did not require him to return them. Here's his footnote 3. Save America statement. Here's the citation. The government is not aware of any valid basis for an advice of counsel defense, but if asserted at trial, it would require inquiry into any attorney communications on which it is based, and under precedent in this district, would require disclosure of any such attorney-client communications. Accordingly, in order to prevent disruption of the trial, the government requests an order requiring advance notice of any advice of counsel defense and timely production of any associated discovery so that any legal issues can be fully resolved well in advance of trial. In filing this motion, the government does not concede the appropriateness or viability of the advice of counsel defense or that a jury instruction will be warranted. The government has conferred with defendant Trump's counsel. They oppose this motion and will respond within the time permitted under the local rules. Background. During periods of time and events set forth in the superseding indictment, the defendant was represented by attorneys on the subject matter of this case. He has publicly stated he was told he had no legal obligation to return classified documents to the government or presidential records to the National Archives and Records Administration, thereby indicating a possible defense of good faith reliance on advice of counsel. For example, on February 10th of 2022, after public reporting that NARA had A, discovered classified documents in the 15 boxes the defendant had returned in January of 2022, and B, thereafter referred the matter to the Department of Justice. Here's a citation there. The defendant issued a statement via his Save America Political Action Committee claiming, without specifying whose advice he purported to rely on. In actuality, I have been told I was under no obligation to give this material based on various legal rulings that have been made over the years. And here's his citation down here. So each of these is just a citation, everybody, so I won't really be going into the footnotes. After the court authorized search of the Mar-a-Lago Club on August 8th of 2022, the defendant invoked the purported cooperation of his attorneys to suggest the search was not justified and posted the following message on Truth Social on August 11th. Quote, my attorneys and representatives are cooperating fully and very good relationships have been established. The government could have had whatever they wanted if we had it. The defendant also stated his approval when one of his attorneys claimed on national television, among other things, that the defendant could lawfully keep classified documents in his personal possession post-presidency. Quote, great job today by highly respected attorney Jim Trusty on Meet the Fake Press. Trusty took them apart on the box's hoax. In a January 19th of 2023 interview with Fox News, the defendant stated, quote, I have every right to have those boxes. This is purely a Presidential Records Act. This is not a criminal thing, end quote. As recently as September 2023, the defendant reiterated his assertion that his conduct was legal. I'm allowed to have these documents. I'm allowed to take these documents, classified or not classified. Boy, he really talks to the media a lot, doesn't he? There's a lot of media talk going on here. Will assert an advice of counsel defense at trial, necessitating the notice and discovery the government seeks here. 2. Applicable legal principles. In order to assert an advice of counsel defense at trial, an affirmative defense, a defendant must show that 1. He fully disclosed to his attorney all material facts that are relevant to the advice for which he consulted the attorney, and 2. Thereafter he relied in good faith on advice given by his attorney. Citing case law here that's affirming the district court's refusal to give advice of counsel instructions, quoting the Miles case, approving jury instruction that good faith reliance upon the advice of counsel requires not only full and complete disclosure of the facts, then known, but also of material facts or information later acquired. A district court may properly decline to give an advice of counsel instruction if it lacks evidentiary support or is based upon mere suspicion or speculation. Citing Cordone, holding that the district court did not err in denying advice of counsel instruction. U.S. v. Petrie, finding no abuse of discretion in trial court's decision to preclude good faith reliance on an advice of counsel defense in case where proposed testimony was at best marginally relevant and any probative value would have been outweighed by risk of confusion. An advice of counsel defense cannot be reasonably relied upon if the advice approves making material misrepresentations to the government. Quote, reliance on approving advice about such obvious dishonesty would clearly be outside of the good faith prong of the expert advice defense. Moreover, the advice must predate the charged conduct in order to form a proper basis of a good faith reliance on an advice of counsel defense. The clear meaning of good faith reliance defense on advice of counsel is that prior to committing the offense, the defendant sought the advice of an attorney and, after disclosure of all relevant facts, counsel advised that the proposed course of action would not violate the law. In invoking the advice of counsel defense, the defendant waives attorney-client privilege over all communications concerning the defense. Citing the Jensen case, by claiming that he lacked intent to defraud because attorneys told him that his disputed transactions were legal, defendant waived the attorney-client privilege with respect to communications with counsel concerning their legality. Citing next the Carnegie case, having gone beyond mere denial affirmatively to assert good faith, USX injected the issue of its knowledge of the law into the case and thereby waived the attorney-client privilege. The Telemundo case, it is well established that when a party asserts a defense, such as the advice of counsel defense, that makes an attorney's advice an issue in the litigation. That party waives the attorney-client privilege. So I think the case law here is supporting this waiver of the attorney-client privilege according to how the government is setting it out. And then last, we've got the Doherty case. By choosing to assert an advice of counsel defense at trial, defendants must waive privilege over all communication involving the subject matter they intend to use as the basis for their defense, regardless of whether the communications come from the attorneys defendants explicitly listed in their notices or wish to select as witnesses. Even when a defendant does not explicitly claim reliance on attorney advice, a defendant's testimony that he thought his actions were legal puts his knowledge of the law and the basis for his understanding of what the law required in issue. Making such a claim thus waives attorney-client privilege with respect to those communications with his counsel regarding the legality of his actions. Once the advice of counsel defense is raised, the defendant must permit discovery of any and all legal advice rendered on the disputed issue. That's such a big piece right here, is that all of that information then becomes available to the government. Blocking access to such discovery requires the exclusion of any evidence of the defense. Accordingly, waiting until the eve of trial, or worse, until after jeopardy attaches, meaning double jeopardy, to raise an advice of counsel defense risks causing substantial disruption and delay, particularly in this case, given the number of attorneys to whom the defendant might point in raising the defense. To avoid such disruption, courts around the country have concluded that although the federal rules of criminal procedure do not address this defense specifically, and then here they're citing Rule 12.1, and then just to remind everybody here what he's talking about, these are the federal rules of criminal procedure here. So anything in criminal court, we have to follow these rules procedurally. They all have to be followed just as much as our substantive rules do. But judges retain inherent authority in order to order defendants to provide formal notice of advice of counsel defense before trial. Let's see here. Shapiro. Courts have broad discretion to impose disclosure and notice requirements outside the federal rules of criminal procedure. where the government has sought pretrial notice and discovery regarding an advice of counsel defense, judges of this court have repeatedly mandated that the defense provide it. And then we have a whole bunch of citations. In the U.S. v. Carver, the court granted the government's motion to compel pretrial disclosure and discovery of any advice of counsel defense. One of the defense attorneys had indicated to the government that previous defense attorneys were potential witnesses who might testify regarding their discussion of company operation, policies, and procedures with one of the defendants, although there was no allegation at the time that any of the defendants would assert they believed their actions were lawfully based on any advice. The defendants objected and cited to two apparent cases in this district. Can I buy a copy of this, or is it only available? Sure, you can get a copy of this. I can't recommend any particular website, but there is a very frequently used website that everybody pretty much uses, and all of our procedural rules are all available. You can get any of these. These are called the Quick Desk Reference Series. They're all available very easily, very inexpensive if you are interested in that. They're also available online. If you just want a digital copy, you can pull them up online as well. But yes, the PDFs. Yes, exactly, VC. So you can have a PDF. But if you do want, like for me, because I use these wherever I go because I'm a dork. So for me, it's nice to have this little version. I have bigger versions of my state rules and procedures. It's a much bigger book than this, and that works out great. But for the federal one, because I don't practice in federal court, I just teach about federal law. So these work out perfect for me. Yes, shop used and save. True. But again, it is online. Do you narrate the audio version? I do not, John. I don't. Although I think I did go through the hearsay rule. I should probably put some of those posts together. Maybe I'll do a series on that. I'll read the rules. Oh my gosh, that's hilarious. All right, here we go. So then we're down to this court appropriately rejected the defense's objections and ordered the defense to provide notice of whether they intended to rely on an advice. Hard copy is great. Oh, absolutely. On an advice of counsel defense approximately 4 weeks before the trial was scheduled to commence. Hold on, I will take a pause for a tea break here, everyone. There are some apps available too that have some of our rules as well, but I can't recommend any particular apps because I always use a hard copy. For me, it just works better. It's easier for me when I'm moving around. All right, number 3, discussion. The defense has made public statements suggesting a possible advice of counsel defense, but he has not provided formal notice of the defense to the government or to the court. Notice that would trigger discovery obligations. To promote fairness and efficiency, the government requests a deadline of 60 days before trial to notice his intent to rely on the defense and produce the concomitant required discovery. Come on, people. By that time, the defendant will be in a position to inform the court and the government of his intent regarding this potential defense. Requiring notice promotes fairness. Fairness dictates that the government should be provided notice and discovery regarding the defense sufficiently before trial. Citing the Dougherty case, noting the principle of fairness that necessarily follows from the assertion of an advice of counsel defense, the advice of counsel defense is fact-intensive. It rests on the specific facts of what the defendant disclosed to his counsel, what advice the lawyer provided to the defendant on the legality of his actions, and what actions the defendant took based on that advice. Discovery about these matters is uniquely within the possession of the defendant, and much of it would otherwise very likely be privileged. For these reasons, the defendant asserting the defense is required to produce discovery to the government, citing case law here. In other words, a primary reason for the defendant's obligation to provide discovery concerning the defense is that the government might not otherwise be entitled to receive it. The defendant should not be permitted to withhold or delay notice to the government of the defense to avoid producing discovery relating to it, and then ambush, oh dear, we don't want any ambushes, ambush the government with the defense during trial. The attorney-client privilege was intended as a shield, not a sword, which is a very, very common phrase we use all the time, although there's no citation. I would subtract a point for that. I'd take a point off for that. I'm just saying. Compelling defendant Trump to provide notice and discovery would also comport with his reciprocal discovery obligations under Federal Rules of Criminal Procedure. If a defendant requests disclosure under Rule 16A1E and the government complies, then the defendant is required to provide reciprocal discovery to the government of items if 1, the items within the defendant's possession, custody, or control, and 2, the defendant intends to use the item in the defendant's case in chief at trial. So let me just show you real quick this rule since I have it here at my fingertips. So this is Rule 16B here that they're citing, but the request is under 16A1E. So let me just show you how that works here. So we have Rule 16A. Oh, look, I had even opened to the page right away. Sorry. Here we go. 16 is a big rule. So discovery and inspection. So subsection A, and then under subsection A, we have 1. So there's 1, and then we need subsection E. So that takes us here. So this is the rule. Documents and objects. Upon a defendant's request, the government must permit the defendant to inspect and to copy or photograph books, papers, documents, data, photographs, tangible objects, buildings or places or copies or portions of any of these items if the item is within the government's possession, custody, or control, and then 1, 2, 3 that they already pulled out and put into their paragraph here. So just as an FYI, on how that works. Finally, while fairness warrants pretrial notice of the advice of counsel defense in this case, requiring it imposes no unfairness to the defense. In light of his extensive public statements, Trump cannot complain that formal notice will prematurely or unfairly reveal a hidden trial strategy, and since he must, in any event, produce exhibits in advance of trial, he will suffer no prejudice in also formally noticing his intent to rely on the defense. Now, this is very much like the government's motion in the Florida case as well. So this is very similar language here. Requiring notice promotes efficiency. Requiring pretrial notice and disclosure will also prevent disruption of the court's schedule and further judicial efficiency. Trump retained multiple lawyers during the relevant period, and the process of disclosure, review, and further investigation by government, followed by potential litigation as to the applicability of the defense in this case, may be time-consuming and, if not done in advance of trial, risks unnecessary interruption and delay. Consequently, if defendant does not provide notice and discovery of his communications with attorneys which form the basis of his anticipated advice of counsel defense, the government will be forced in the middle of trial to request the court halt the trial in order for the government. Oh, we don't want that. We don't want any halting going on, everybody. That would be too much. No halting. To review a large quantity of new information. Such an approach would force the court to rush headlong into a delay and inefficiency. If the documents are not produced before trial, and we're citing this case here, the trial might be delayed as it is likely the government will need time to undertake further investigations suggested by information contained in the documents. Moreover, the discovery and investigation process surrounding the advice of counsel defense may raise issues requiring additional briefing before trial in connection with the discovery process and the scope of defense itself. Citing Shapiro, quoting, and adopting the sound reasoning of Crowder in granting a similar pretrial motion seeking notice and disclosure of the defendant's advice of counsel defense. Notably, producing and identifying an otherwise privileged document will operate as a subject matter waiver for all related communications. All right, I need to pause for a tea break again. All right, and then we're citing the Dougherty case again. If the defendant fails to provide timely notice and discovery, the court is within its discretion to preclude him from asserting an advice of counsel defense during trial. Keep in mind again, everybody, sorry I forgot our sticky note here, but we're in Florida. All right, so we are in, it's vanilla peppermint tea. So we are in Florida. So he's talking to Judge Cannon here. Let's kind of keep that in mind as well. The deadline will provide the parties and the court sufficient time to resolve any issues related to the defense, including requests of any additional defenses disclosures that may be required. Conclusion. The court, the parties, and the public have an interest in a fair, orderly, and efficient trial. The court should build an appropriate interval into the pretrial schedule to ensure that all disclosure, investigation, and litigation resulting from notice of any advice of counsel defense can be addressed and resolved in an orderly fashion. For that reason, the court should enter an order requiring Defendant Trump to provide notice of his intent to rely on such a defense and all associated discovery no later than 60 days before trial begins. Respectfully submitted, Jack Smith. So, again, we have all kinds of affirmative defenses. And when you have, and then this is just the sign that we use for defenses, everybody. So whenever you have an affirmative defense, the most common affirmative defense, of course, is self-defense. You have defense of others, defense of property. Those are just our very most typical affirmative defenses. We can have other affirmative defenses like alibi. Probably, there we go. Alibi is another one. So if you're asserting any of these, you have to plead them out as an affirmative defense. But what they're saying for advice of counsel, that they don't have a specific rule claiming that as an affirmative defense. Self-defense and the other defenses are listed in the rules, but this particular affirmative defense is not. So that's why they're saying it should be pled just like all the other affirmative defenses. All right, so there we have it. That is the Florida order, everybody. So that's the update out of Florida. Goodness. What is stand your ground defense? That's a great question, Chris. So stand your ground. Let me draw it out for you, okay? So we have this is why I went to college right here, everybody. All right. Here's our house. We have what's called the Castle Doctrine. All right, Castle Doctrine here. And then we have anywhere outside of your house. All right. So this is the public, anywhere else. So if you are here within your house, you've got the Castle Doctrine protecting you. So if someone is coming at you, you can use a certain level of force in order to protect your own home because it's your own home. But when you're out in public, we've got two different ways of going about it. So we have two ways of protection. One is stand your ground. So if someone, this is you, okay, and let's put some hair. There we go. So someone is coming at you with, they're angry, okay, they're coming at you aggressively. You can do whatever you need to do to meet their force with equal force. All right, equal force. So, but the other one, the other way that we go about it is called the retreat doctrine. All right, so if you're standing here and you're in the retreat doctrine area and someone's coming at you and they're angry, okay, they're coming at you. So here you can say, leave me alone and meet with equal force. For the retreat doctrine, it means you have to run away. Run away! So you're like running away. Run away. All right, so here you can say, leave me alone, equal force. Here you have to run away. All right? Yes, so those are our two ways. both of these have to deal with being in public. All right, so you're in public. The castle doctrine is what governs if you're in your own home. So if you're in your home and you're saying, I'm standing my ground, that's incorrect. You are covered by the castle doctrine. But when you are in public and you're standing your ground, you're saying, I'm going to meet you with equal force, as opposed to running away. That's it, everybody, okay? So there you go. That's free, no charge for that. But that's the long and short of it. I think people think of it as much more complicated than it actually is. And I think it's because it kind of seems more complicated. Equal force. So equal force is really controversial. All right. So we have different levels of force. And again, I'll just take a minute here. Right. So there's different levels of force. There's this kind of force, and then there's this kind of force. That's it. Those are the categories that we're looking at when I'm saying equal force. So is it this kind of force or is it this kind of force? So if someone's coming at you with this kind of force, you can meet them with that force. But if they're coming at you with this kind of force, then you need to meet them with this level of force. Some people may argue different weapons are at different levels here, or people who with training are at different levels for how much this could be for force for them. But you're looking at the average person and an average reasonable person in that situation. Do they feel that this force is coming at them? And if so, they can meet it with the equal force. This is what I mean by equal force, okay? Yes, it's self-defense, and this is not legal advice. All right. Not legal advice. It's just basic legal knowledge, legal information. But yes, this is so this is self-defense. And again, if you are in a retreat state, you need to run away. Run away, run away. But if you're in a stand your ground state, you can meet force with equal force. And by force, I mean, is it this force or is it this force? And it's different per state, exactly. Exactly. Yes. Yes, exactly. So there you go, everybody. There's that's your little bonus lesson for tonight. Your little mini lesson, your mini lesson inside all the other lessons. Yes. But again, everybody, stand your ground is not when you're in your own home. That's called the castle doctrine. And a lot of people mix this up. Right. So the Zimmerman situation, all right, valid question. We're in public, and that entire issue with the defendants and the self-defense was the credibility of the witnesses and whether or not who was the first aggressor and who was the second aggressor, right? So who engaged first? Those were the questions. And then the jury decided that. And their jury actually was smaller than 12 also. So they had less than a 12-person jury. So they had a small jury. That's where Travis is in his castle. Travis is in his castle. Go to your castle, Travis. Be safe. Yes, yes. The entire issue with the Zimmerman case was that they had to figure out who that first aggressor was. And also, again, what level of force was being used and by whom. And when they listened to the phone calls and the eyewitnesses' accounts, the jury, which again was less than a 16-person jury, made that determination. So there you have it. That's the 2-minute version of the Zimmerman situation. Oh, absolutely. You're welcome. You're welcome. There's so much information on Zimmerman, and it's one of the cases used to teach about self-defense. So, I mean, it's how to do it and how to not do it. So that case was, it was not a good case. That was a bad case. All right, here we go. So next, let's go to DC. All right. Yes, less than 12 people exactly. That was a huge part of it. I think they had 9. I think they had 9 people in Florida. And that makes a difference. I think, 9 people versus 12 people makes a big difference. All right, everybody. So back to Yes, oversized brief. Back to DC. So here we've got Mr. Trump, and the government has said we need to file a brief because we've got briefs due. All right, we've got all kinds of stuff due. A motion to dismiss opposition is due by the government tomorrow. So remember, I went through the motions that defendant had filed saying motion to dismiss based off of presidential immunity, motion to dismiss based off of multiple different reasons. And so what the government's wanting to do is putting all those reasons into one brief. So they ask permission from the court, which is what you're supposed to do. Defendant is saying we don't think that they should be allowed to put all of the defenses into one brief. They should do 3 separate briefs. So that's what this motion is about. I'm not going to do a sticky note because it is only 1 page. It's 1 page and then the signature on the back. So I'll just remind everyone that the name of the district is up here. So this is jurisdiction. Anything in orange is the District of Columbia. And also anything in orange here means it's the defendant. So President Trump's response to prosecution's motion for leave to file oversized brief. The prosecution requests leave to file an oversized consolidated brief in response to President Trump's motion to dismiss on statutory grounds. So here's his first motion. Motion to dismiss on constitutional grounds. And so I guess those are just 2. I thought there were 3, but the third one was actually the indictment language is what he had wanted to change. That was the night when he filed a whole bunch of stuff all at one time. Here. So the prosecution advises its proposed brief would exceed the 45-page limit for responses provided by the local rule. The court should deny the prosecution's application. Is 45 typically the max? Yeah, I mean, around in that range. That's pretty normal. Because the motions raise distinct basis for dismissal, the defense believes it's more efficient and organized for the briefing to remain separate. Do you have your red pen ready? Yeah, good point. Good point, everybody. Here we go. We're ready. We're back. Because the motion raises distinct basis for dismissal, defense believes that it's more efficient and organized for the briefing to remain separate. This will avoid confusion over the application of any arguments to the parties' respective briefing and will also keep the record clear on appeal by either party. To the extent the court grants relief, it should prohibit the prosecution from discussing either motion for more than 45 pages, inclusive of any combined introductory or background sections. For example, the court should not permit the prosecution to address constitutional issues for 60 pages. All right, that's just rude. Finally, President Trump construes the prosecution's application as concerning only his proposed response brief. Accordingly, President Trump intends to file separate replies in support of his motions consistent with local rule and this court's prior order. Any alteration to that standard right should require a separately noticed motion and full briefing. All right. And then again, PHV means pro hoc vice. So whatever. This is hashtag petty. That's my own personal opinion on that one. All right, here we go. Rudy. No. All right, quick tea break, everybody, and then we'll get on to the next one. Okay, here we go. Next up. So this is the District of Columbia. Again, we're in orange, and then this is green, so it's the government's opposition here. And I will get a sticky note up for this one because it is just a couple of pages. It's not very long, but it is a couple of pages. This is the last motion that I have here, so I'll do a quick review of updates after I finish this motion. And then I did want to kind of touch on the 14th Amendment cases briefly too. So I'll also go into that after we finish this one up. So we have the DC case, the U.S. v. Trump. DC case. And this is the government's motion. Against delays. We'll just put it as delays, against delaying here. Okay, here we go. Whew. All right. In two related motions, the defendant continues to try to undermine the court's carefully reasoned pretrial schedule. Ouch! That's a tough first sentence, everybody. That's harsh. He's not playing around. First, all right, here we go. First, he seeks to stay all proceedings until the court rules on his executive immunity motion. The government will separately address that motion no later than Monday, November 6th. Right here. Okay. When responding to other outstanding motions. Second, apparently, in the alternative, the defendant asked to move once again the deadline for filing motions to compel and Rule 17c motions. Specifically, he requests permission to file motions to compel on a future contingent basis to be determined by the defendant. Yikes. Oh, dear. And he requests an extension of 3 months for filing Rule 17c motions, so the motions would become ripe the Friday before the start of trial on Monday, March 4th. And that timing is a bit different. As before, the defendant's requests are designed to disrupt the trial date and delay the resolution of this matter. The court should deny the motion. Number 1, background. The court allotted the time before trial through a series of reasons, deadlines, with input from the parties. Initially, all pretrial motions except motions in limine and motions to suppress were due by October 9th of 2023. The defendant previously moved the court to delay that deadline by approximately 2 months, and the court granted the defendant's request in part, extending the deadline to October 23rd, except for motions to compel Rule 17 motions, for which the deadline was extended to November 9th. Right here. Just so you know. In setting the November 9th deadline, the court, having had the benefit of the government's prior submissions and arguments, noted that the discovery materials in this case are well organized, but significant and additional time to review them may be useful to the defense as it considers motions related to the acquisition of evidence. The court also emphasized the disadvantages of backloading the pretrial schedule. Since then, pretrial preparation has proceeded. Most relevant here, the defendant filed a motion to dismiss October 5th, a motion for Rule 17c subpoenas, 3 other motions to dismiss, 3 others. That's what I thought. I thought there were 3 on file. He'd only put 2 in the previous piece that we talked about here, but he's saying that there were 3. And a motion to strike. The defendant also sent the government various discovery letters, including ones dated October 15th and October 23rd, with numerous erroneous assertions and overbroad requests. That's what the red pen's for, everybody. For example, the letters assert that the prosecution team includes the almost 3 million civilian active duty and reserve members of the Department of Defense. That's funny. That's funny. The 260,000 employees of the Department of Homeland Security and the entire intelligence community, among other non-Justice Department agencies. That's so funny. Oh my gosh. Insists that the government's Jenks review. So this is the review where they're saying if you've got exculpatory evidence for witnesses, you need to give that over. Must encompass the witnesses' personal email accounts, personal phones, and personal messaging applications, and call for the production of documents far exceeding the scope of the charges in this case and outside the possession of the prosecution team. The government responded to these letters in writing on October 24th and November 3rd and set forth its responses and positions, including regarding the limited scope of the prosecution team and the untenable nature of certain discovery requests. The government's responses also point the defendant to certain documents already produced in discovery that were responsive to his requests. So they're saying, we already told you, we gave you a whole bunch of stuff. Oh, this cracks me up, everybody. It just cracks me up. In his most recent motion to delay the pretrial schedule, I don't think that's the name of the motion, but okay. The defendant asserts that he has worked in good faith to comply with the November 9th date for filing any remaining motions to compel and Rule 17c motions, but nevertheless is unable to do so given the enormity of the discovery and the time required to confer with the prosecution. Referring to the November 9th date as an inflexible global deadline, the defendant urges the court to adopt a protocol that would functionally subordinate to the defendant the court's responsibility to manage the pretrial schedule in an orderly manner. As with each of the defendant's other delay tactics, the government opposes the defendant's motions. Rudy's going into different businesses. He's going to be selling hair pieces. I'm not sure if he's qualified to do that. Number 2 argument. The court has taken a reasoned approach to setting pretrial deadlines in this matter, but the defendant remains unsatisfied, now asking the court for an indefinite time frame for filing motions to compel discovery and 3 additional months until February 9th of 2024 to file unidentified additional Rule 17c motions. Since indictment, the defendant has routinely forecast the possibility of raising various motions with the court while at the same time seeking to delay filing them. And then we have footnote number 1 here. For example, in the current motion alone, in addition to motions to compel and Rule 17c motions, the defendant indicates that he also intends to litigate whether an expired Congressional Select Committee is part of the prosecution team, and intends to raise discovery issues with the court in a forthcoming motion. Oh my goodness. Oh my goodness. No further delay should be permitted, and the court should exercise its discretion to decline both requests. Again, that's that Federal Rule of Criminal Procedure, which comes out of this. The defendant's principal argument for delay is that he will not be able to complete his review of discovery by the current deadline. The defendant's robotic incantation of an argument he has made at least 3 times does not suffice. That's an interesting use of the word robotic. As support of this occasion, the defendant describes an incredibly time-consuming process of identifying certain related documents within the government's productions. The defendant has never brought these purported concerns to the government's attention by email or in any of his lengthy discovery letters. Ouch! Does the defense have to notify the prosecution every time before they file these motions? You know, you can talk to the other side. You should be talking to the other side when you're filing your motions and seeing if they will agree. Because if they agree, then you won't need to file motions separately. You can file a joint stipulation or a joint motion. So it's always good to ask where the other side's at with it. With every discovery production, beginning with its first on August 11th, the government has offered the defendant assistance, including through paralegals and litigation support staff. If he has questions or difficulty accessing discovery material, that offer stands. Oh, well, that's nice of them, isn't it? The defendant's misleading criticism of the way the government produced emails exposes that he's grasping at straws for an excuse to delay these proceedings. Now, that's harsh. For example, he alleges without support that the government did not follow a standard procedure regarding threading, a form of organizing email messages. Do you guys remember that? Or do you all remember that? When we went into the motion the defendant had filed and he said, the government's not even using the proper method for keeping track of the chain of emails. Do you remember that part of the motion? It was a pretty harsh blow. So now he's coming back. Government's coming back here. The fact of the matter is that the procedure the government followed, which constitutes a best practice, is to produce discovery in a load-ready files identifiable by the source from which the information was received, whether from lay witnesses, government agencies, or email providers. This leaves the defendant free to use the electronic platform of his choice to perform threading, deduplication, filtering, and any other techniques he desires to facilitate his review of discovery, all of which services, as the government previously pointed out to the defendant and the court, are offered by the defendant's e-discovery vendor. Oh my goodness. Oh my goodness. Ouch. according to its own website. Oh my gosh. Oh my goodness. That's painful. That's painful right there. In any event, the government states again here, we stand ready to work with the defendant, including through automated litigation support staff, if he has difficulty accessing discovery material or comprehending its organization. Oh my gosh. Harsh, harsh. The defendant also posits that even if the discovery were well organized, and it is not, it still must be reviewed. And that review for the purpose of potential motion practice requires more than simply reading pages. Oh my goodness. But the defendant's rehashed argument that the size of the government's production compels relief already was rejected by the court when setting its initial scheduling order. The court, quote, the manner in which the discovery in this case has been organized indicates that the government has made a considerable effort to expedite review, certainly beyond their normal discovery obligations. Government filing describing how roughly 65% of the government's first discovery production consists of materials of which the defendant has functionally had access are duplicative or do not constitute Rule 16 discovery, and that the burden of reviewing discovery cannot be measured by page count alone. The defendant's continued attempt to portray the volume and form of discovery as extraordinary and unduly burdensome in the face of modern electronic discovery. I'm sorry, everybody. I'm sorry. Harsh. It's harsh, Jack. It's real harsh. And his substantial resources contrast with reality. Oh my goodness. Oh my gosh, I need a moment. Just a minute. I'll take a tea break. Oh my goodness. Yikes. Okay. Substantial resource. All right, okay. Maybe the defense didn't waste their time filing the same briefing repeatedly. They didn't have this time. That's such an excellent point, Daisy. For this case, the defendant has employed at least 3 law firms, 5 counsel of record, 3 additional counsel of record in the D.C. Circuit, another attorney who has recently sits at a counsel table despite not having entered his appearance. Dang, I feel like this is on fire. Like it's shooting fire beams. Additional undefined back office support from other attorneys. Here's footnote number 2. Oh my goodness. Here we go. So we've got Trump expands criminal defense team and an outside e-discovery vendor. The court, but let's not overlook the fact that the defendant has considerable resources that every criminal defendant does not usually have. The defendant noted as much himself outside these proceedings. Can you give a brief summary for those who need a bit of extra information on what's happening? Oh, absolutely. This is a great moment, actually. Oh, all right. So this... This is the government's opposition to the defendant's motion for an extension of time. So the defendant asked for more time to file pretrial motions. The defendant went in and said that the government's discovery was a mess, that it wasn't organized properly, it was hard to find, they had to read page by page, the process they used wasn't good, like it was a mess. And so it was taking up so much time, they needed an extra 3 months to be able to go through it. So they're asking for more time. The government is saying, no, you don't need more time. And so that's what this whole motion is about. Oh my goodness. That's pretty much it. And he's a little bit spicy about it. It seems like he's a little bit spicy. Yes, exactly, Jen, exactly. All right, so defendant noted as much himself outside these proceedings. So footnote 3, remarks in Sioux City, Iowa, available here at the YouTube. I have $100 million worth of legal fees, and they're doing good. At least I have good lawyers, because you can spend $100 million and have lousy lawyers too. It happens. Ow! Oh my goodness. Oh my gosh. It's getting ugly, everybody. It's getting ugly. The claim otherwise in... All right. I'm going to pull myself together. The claim otherwise in his motion is a delayed tactic. The defendant further complains that the prosecution continues to serve discovery productions on a rolling basis, as though this were both a surprise and a detriment to the defendant. Rolling productions of discovery are standard, as evidenced by that's true, they are standard, court's pretrial order, noting that the government's duty to disclose is ongoing. I think Jack needs a lollipop. He does. I should send him some. I think last time we sent the judge a fruit I need to send the judge a fruit basket, Judge McCaffey in Georgia. And now Jack needs a box of lollipops. And setting deadlines into the 2024 for the government's discovery production. Moreover, the government's most recent productions have consisted largely of documents identified for disclosure through quality control measures, as well as open source information regarding the defendant's own public statements, and constitute a small percentage of the total discovery provided in this case. Should it happen that a future discovery production provides the defendant with good cause for late filed motion to compel or Rule 17c motion, he will be entitled to seek relief from the court. Besides being unnecessary, the defendant's requested schedule is also unworkable with respect to the motions to compel. The defendant requests to proceed in two phases. First, he asks that the court direct the parties to confer in good faith regarding the defendant's October 15th and October 23 letters, with the understanding that the defendant will file any motions to compel within 10 days after the meet and confer. But the parties have already conferred. Oh dear, that was not in the defendant's motion. This was not listed in the defendant's motion. The defendant provided his assertions and requests in writing, and the government made its position clear in response. Oh my gosh. If the defendant wishes to confer further, the government stands ready to do so. The government's standing ready quite a bit. This motion. Otherwise, the defendant knows what he wants and should ask the court for relief within the scheduled deadline. Second, the defendant proposes that for any discovery the prosecution has not yet produced or which the defendant has not currently revealed. I'm sorry, this is just such a harsh motion. The defendant will file a motion to compel within 10 days of any future meet and confer. This formulation results in an indeterminate, unworkable schedule controlled by the defendant rather than the court. The defendant provides no basis for the court to adopt this perplexing protocol. Similarly flawed is the defendant's proposal to extend the deadline for Rule 17c motions until February 9th of 2024, a date 2 months later than the defendant's previous denied request. For a deadline of December 8th. Oh my gosh. Wow. Wow, Jack. Wow. The defendant correctly notes that Rule 17c's chief innovation was to expedite the trial by providing a time and a place before trial for the inspection of subpoenaed materials. But his proposed schedule to file motions to obtain subpoenas returns before trial is self-defeating. By extending the deadline to February 9th, the motions will not be fully briefed and the defendant will not be able to issue the subpoenas until March 1st, 3 days before jury selection begins. And then here we have footnote 4. The defendant also fails to explain how his proposal would not conflict with other deadlines, such as turning over exhibit lists, December 18th, and filing in limine motions, December 27th. December 27th is going to be a very exciting day, everybody. I'm just putting that out there. More fundamentally, the defendant's alleged concern about large volumes of late subpoena returns appears unlikely, though estimating the volume of the information responsive to the defendant's hypothetical subpoenas. Oh dear. My goodness. Okay. Hypothetical subpoenas to recipients he does not identify for documents. Hold on. I got a question. Rule 17C, right? Okay. Oh my goodness. All right. Just a minute. Let me get the rule for you here. Okay, so Rule 17C subpoenas are not discoverable device and must seek relevant, admissible, and specific information. So 17C subpoenas, we've got subpoenas under Rule 17. We've got the content of subpoenas, defendants unable to pay for subpoenas, what happens then? And then producing documents and object subpoenas. So these were the subpoenas where they had said all of these documents, all this evidence had gone missing from the Jan 6 committee, and they wanted all of those documents. So that's what they're talking about. It's basically a request for production that you bring documents with you when you're testifying. Oh my goodness. All right. And must seek relevant, admissible, and specific information here. Any subpoena returns are unlikely to be as extensive as the defendant suggests. So again, the government is saying, look, we don't even know what you're talking about. Your subpoenas. The defendant's motion is another transparent effort to delay the resolution of this case. The court should deny the motion. Oh my goodness. Okay, everybody. So there we have it. That's a little spice from Mr. Smith with regards to the DC case. Oh my gosh. I think he's getting a little tired of it, everybody. I think he's getting tired of the bologna sandwiches. Have they decided? No, they haven't decided yet. The court hasn't come back with an order that I've checked. I've checked before I went live today. So yeah, he's getting a little snippy, Tiffany. I think that's a good way to put it. I can't blame him. I can't blame it. Doesn't seem like a coincidence. DC and Floyd's Union George. Oh, absolutely. You know, I think that it's all connected here and there. I think that there are definitely some bits. Anyone can put him in his place as Jack. Yeah. Blake, if you need help, Jack. Oh my gosh, yes. I might send him a basket of candy. I'm afraid though, because right now they're probably getting so many baskets of stuff that they're probably like really scared to get a basket. I might need to wait until a later date when the basket's not suspect. Oh my gosh. How many people work on Jack's team? Great question, and I'm not sure. You know, I would doubt it would be more than a couple of handfuls of people, honestly. I'm sure he's got tons of assistants, and there are tons of attorneys who are arguing, but the attorneys who have filed as attorneys of record for the government is just a handful. So it's them plus, you know, whatever assistants that they have. So it's really not that much. Issued a minute order to authorize the oversight draft. Really? Oh my gosh. Hold on, everybody. Let me double check. That's exciting. Good for her. All right, I've got the DC docket pulled up here. Government's motion for leave to file. The oversized brief is hereby granted. The government may submit a combined opposition brief to defendants' motions to dismiss based on constitutional grounds and the motion to dismiss based off of statutory grounds. The brief may not exceed 90 pages in total. The discussion of each motion therein shall not exceed 45 pages. Signed, Judge Chutkin. Excellent, everybody. We love that. We love that. Yeah, okay. So we love that. That's fantastic. So this was approved. Approved. Oh, wait, I'm sorry. This was not. This was approved. Approved. Approved a large brief. We love large briefs. Large briefs are the best briefs. All right, here we go. Hypothetical subpoenas. Right. All right. Okay, everybody. All right. So let's do a roundup here. We'll do it. And then after I do, again, a quick overview, I do want to kind of get into this 14th Amendment question that's been going on. We've got a lot of 14th Amendment stuff, so I thought I would do a brief overview of those things too. But here's the update, everybody. Based in reality, yeah, that's a good question. we've got Mr. Trump testifying in the civil case on Monday, so tomorrow. We have a reply to opposition and the pretrial motions. So that was what we just went through. That's already been filed. We just went through that. Motion to dismiss opposition. So that giant brief is due. Then we've got Ivanka testifying here on Wednesday. Now, these ones here in pink, these notes are the Florida case, but those are kind of up in the air right now. I'm not really sure what's going to happen with that. We also then have the pushed date of the pretrial motions then set for the 9th for DC. So that's what we've got for this week going on in the Trump world. So in other news, we do have SCOTUS oral arguments on the 7th. So let me just write that in. We have a big Second Amendment case coming up. Oh, the monkeys. Oh, we love the monkeys. So we have a Second Amendment being argued here. We should at any time hear back from the Minnesota case. I'm sorry, from the Colorado case. We should be hearing back anytime, I would think, in the next few days. So that's probably what else is going to be coming up. Minnesota, I'm not sure how long it's going to take them to make their decisions. But so that's it. That's it from the Trump world, everybody. With that. Now, this week, just so you know, for my live schedule, I will be back. Tomorrow, we'll see what motions we have that have been filed, and we should have a brief by then, so I'll probably go over that. Tuesday, I'll probably do a recap of the oral arguments for the Second Amendment, and what I'd like to do also is just take you through an overview of those Second Amendment cases. So I'll just walk you through those on Tuesday. Wednesday then will be sub-chat only, and I will be going through, I think I'll go through Cohen's deposition. I think that would be pretty fun. Judge Chutkin keeps it up. Could she be charged with obstruction? Or Judge Cannon? I don't think so. It takes a lot to obstruct. At this point, I don't see anything at that level yet, but at this point, I'm not saying that it couldn't happen, but it's unlikely. So we'll do Cohen's deposition then for sub-chat only on Wednesday. Then Thursday, we'll do a review, but I also have, I do want to go through Judge Cannon's, speaking of Judge Cannon, the motion where she was overruled. So I'll go through that on Thursday. And then Friday, I've got one more case. We'll do a review, but we'll probably go through the Bannon indictment on Friday, and probably we'll see about maybe just an overview of the TikTok case. He literally bribed her. Yes, I know. It's a lot. We're still not there yet. Not quite there, but eventually we will be. So that's kind of what my tentative schedule then is for this week, everybody. 7 o'clock Central Time. Then we'll go through each piece. And of course, if anything interesting and unique comes up, we will definitely come up. When was she overruled? So she had a decision regarding warrants and a special master. And she said the way that she held, she was overruled by the 11th Circuit. So I've got their opinion on why she was overruled here. So this is the case. It's an appeal, 11th Circuit, and this is where she was overruled. So they held that she was wrong. And so I think it'd be good for us to kind of go through and explain and figure out how the court overruled her, where she was wrong, what decisions she made, and then we can kind of assess, where she's at with that, where she was at. So I think that'll be good for us to kind of go through and review that. It's not a very long order, actually. So we'll go through that. November 15th, Colorado arguments. Really? Okay. That's good. That's good to know. So that's, oh my gosh, thank you, Sunny. Oh, that's so sweet of you. I appreciate that. All right, everybody. So that's the update here. Now, for those who are interested, I did want to do kind of an overview, a review here of the 14th Amendment Section 3 cases that have been going on. So we've got 3 cases now. We've got Colorado, we've got Michigan, and we've got Minnesota. 2 of the cases have already been argued. Michigan was just filed. So there's been a lot of talk and a lot of bits in the news regarding Section 3 of the Constitution. So I thought we could talk about it a little bit and just do kind of a Q&A and explain it a bit better. So under the 14th Amendment, which was ratified in 1868, so we've got multiple sections. The 14th Amendment's complicated, very complicated. But Section 3 states here, and I think VC, you had pointed out an interview, and I took a look at that interview. So let me try to explain this language here again. Did Minnesota allow the case? They heard the case. Their Supreme Court heard the case. They've not decided it yet. So no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or a judicial officer of any state. And then here's the key piece. Here's the key piece to this, all right? To support the Constitution of the United States. All right, so this is where I'm going to kind of split from this narrative we've had before, because we've got a lot of questions. What's an insurrection? What does engaging mean, right? Those are the big questions. Some people call this the disqualification section. So it just means if you've done this, you're disqualified, you're out. Other people are saying, we've got to get the Secretary of State involved and various other things. So let me kind of break this apart here. So to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same. So what I think has been brought up here just within that interview that you were talking about, VC, but in general, is what does this phrase mean, against the same? So if you have engaged, right, so you've taken an oath to support the Constitution of the United States, and you've engaged in an insurrection. Well, everyone's asking about what an insurrection is and what engaging means, right? Do we need a conviction? It doesn't say conviction, right? But what is also being raised here, and then the second part says, or given aid or comfort to the enemies thereof, but Congress may vote by 2/3 of each house to remove such a disability. So the given aid or comfort is the second clause. So we've got two clauses. One here, engaged, and the second is aid and comfort. Now, one thing a lot of people may not be getting out of this is if you take this oath to support the Constitution of the United States, and they're saying you engaged in insurrection or rebellion against the same. Against the same means against the Constitution. So the insurrection is against the Constitution, not against the United States of America. So that's the distinction that's being made. So when we're saying, did you engage? What does that look like? What's an insurrection? What does that look like? But the key here is not whether this was an insurrection against the United States. It was an insurrection against the Constitution, which challenged the very core of democracy. Yes, exactly. Thank you, VC. So, and he's exactly right. Because this phrase here, against the same, means an insurrection against the Constitution. So were his actions an insurrection against the Constitution itself, not against the United States of America? That's a much easier question to answer than was there an insurrection against the United States? Well, that's not the question. The question is, was there one against the Constitution? Was he engaged in an insurrection that went against the piece of the Constitution? And that answer is pretty clear. So that's the language that he was talking about. Oh, absolutely. Yeah, and both could be argued. But, we want to take the path of least resistance. And so if we're saying there was an insurrection against the Constitution, that goes to the intent of what the 14th Amendment was originally put into place for, right? Because when the North and the South broke up, the South was saying, we no longer believe in the Constitution. We want our own Constitution. So they pulled away from the Constitution, said goodbye. And so the language of this is saying, you actually engaged in this insurrection against our Constitution. You rejected our Constitution. And because you did that, you cannot come back into a sworn office again. And it makes sense. Again, the South had their own Constitution. It was the Southern Constitution, which looked very similar to the regular Constitution, but with a few changes. But because of that, they're saying if you reject that Constitution, then you're out. So that goes to the historical background behind this section. Yep. Yeah. And, again, this is something that is, we need to kind of hash this out. We need to flesh it out and figure out exactly what we're talking about here. So with this section of the code. Now, just as a quick reminder, when we pull up the Colorado case here, it's terribly out of order. Just a minute. When we're pulling out their questions, they're saying again, we're looking at, was this an insurrection? And did he engage in it? So those two terms, an insurrection and engagement. But the question is against the government, not specifically against the Constitution, which is what the judge was talking about in that particular interview. And either way, it works, everybody. But I'm saying that there are just a couple of different paths to the same answer. And it's the same in the Minnesota petition as well. So this is the Minnesota petition. Here, took an oath to uphold the Constitution, so we needed that. And then the next piece, they're saying his scheme to overturn the government. So in Minnesota, they're saying he had tried to overturn the government as opposed to saying that he was committing an insurrection against the Constitution itself. So it's just another argument that's being made. Who decides? The courts. The courts decide. So, one of the arguments that was presented in the Minnesota case was, this will set a precedent then for all 50 states to make their own decision individually about what we're supposed to do in this situation. And, the other side of that is, well, that was what was intended. We need to have some continuity. Of course, the U.S. Supreme Court will ultimately rule on it, but how each case gets handled will be up to each individual state, because it's up to each individual state to put the names on the ballot. So that's where we have a federalism issue. So the federalism piece says we need to have a certain number of electors in order to elect the president. But the federalism piece, the state piece, is that it's up to each individual state to set their ballots up how they want under their own laws. So it kind of leads us to this issue between state and federal government. Yes, Colorado's available on C-SPAN. It's very interesting. Yes, absolutely. It's very interesting arguments that have been set out. Again, but this language of the 14th Amendment is, it's all over the news. A lot of people are talking about it. A lot of people are trying to figure out exactly, what the words mean, what the historical context is, and those kinds of things. How many to get them off the ballot? Here's my prediction, everybody. Here's what I think could happen. I think each individual state eventually, the states, once Colorado comes back, and whichever way they come back, again, can be appealed. But once Colorado comes back, everybody was going to file. We're going to see all the other states fall into line and file. And I have no doubt the petitions are ready and waiting in order to see what happens. And they'll be filed. And it will be a state-by-state situation until the U.S. Supreme Court comes back in and solidifies it. Now, when will they solidify it? I don't know, because we've got the primaries coming up, right? In just a few months. We've got the caucuses in Iowa starting, that second week in January. And then we've got New Hampshire right after the first day of the DC trial, so March 5th, I think. So those deadlines are coming up quick. And so in order to even get the practical issues of ballots printed and various other things going on, I think the states will one by one kind of do their own thing, and we will have 50 different situations. Could take a year, yep. Florida may not, yep. How do you think Colorado will rule? I do not know. I honestly do not know at this point. I just do not know. When does this happen in Colorado? I think we'll be getting a decision back from the judge anytime now. I think within the next few days, she'll make her ruling on it. Yeah, she'll make her ruling in the next few days. And then after that, it'll be fast-tracked through the appellate courts. But even once it's fast-tracked, once she makes her decisions, then the ballots will be created, right? So they have to send in the order for how many ballots for the primaries. So in order to do that, that order has to be put in way ahead of time. So she was saying, I think the end of November or the beginning of December is when they have to have the number in and what's supposed to be written on the ballot. So she needs to get her decision, and what's written on the ballot will be based off of her decision. But the whole appeals process will continue to go on. Oh, it'll be appealed. Absolutely. It'll continue to be appealed, but the practical part of it will be based off of what her decision is that comes in. Whether she will order the Secretary of State to come in with their authority and make that determination that they're disqualified or that he's not disqualified. The court will come in with that, and then whatever happens is how their ballots will be printed up, and it'll continue through appeals after that. But it'll be the first domino, and then everybody else, it'll be, clink, 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 clink. Of course, everything will be appealed repeatedly, but once her decision comes down, it will set that precedent in Colorado, which sets it for the rest of us. There's no decision made by the date what will happen. There will be one. She has said, I will make the decision and in time in order for the ballots to be printed on time. And, we just kind of don't think about the practical aspects of it. But she has said, look, I know the deadline. I will have an order done. She just said it straight up. She's like, yep, it's going to happen. When there's an appeal, will his name be on the ballot? Whatever the Colorado judge decides is how their ballots will be printed. What happens on appeal, that'll be taken care of later on down the road. So if she says his name cannot be on the ballot and it's appealed, how they can fix that or whatever on appeal, that'll be dealt with later. But the ballots themselves, if she says he's not on the ballot, he won't be on the ballot. If she says he is on the ballot, he will be on the ballot. So whatever the judge decides is how their ballots will be printed. Everything else will be taken care of later. Could be. How long will it take? SCOTUS, good question. That's a good question. And I'm not sure. I mean, everybody knows how important this whole situation is. And, Minnesota's like, we realize how important it is too. And they've got a very interesting Supreme Court up there, actually. So, it will be interesting to see how it goes. I have no doubt SCOTUS is already thinking about it. They're already talking about it. They're probably already meeting about it. They already know what these issues are. They probably are already starting to formulate how they're going to rule on issues like standing and so on. Those are already going on in their discussions, I have no doubt. So they know that this is on the fast track to them. So it will be an expedited situation without a doubt. Yep. Yes, that they're going to have to print as at risk. True. But you have to, you've got to make the choice. I mean, somebody's got to kind of, pull the trigger, so to speak. And just for the practical purposes of getting things done logistically, somebody has to make that decision. And this judge has that authority. Duty to support the Constitution. Was this in the court filings? So, no, it was argued, though. He argued it. His attorneys did argue that in the Colorado case, that there was no duty. And the argument was weak. It was pretty weak. It wasn't supported by case law. How could they rule in favor of Trump here? It just depends. It just depends on how this judge feels in Colorado. If she feels like there was enough of a basis in order to allow the Colorado statute to give the authority to the Secretary of State to disqualify a candidate from the ballot, she has to make that determination. Or if the Colorado statute does not give the Secretary of State the authority to pull him from the ballot, that they have to follow the Republican Party's recommendation. She will make that determination under her Colorado Code section. That's what she has to do. This is about Colorado law. It's about how their law is written. So she's interpreting their law. Yep. Is there precedence? No, there's no precedence in Colorado. The only precedence is in New Mexico for a county person who had been convicted of January 6th activity. That's the only precedent that there is under 14 Section 3. There's some precedent way back in the 1900s regarding World War I, but it's weak. So it's not it's not persuasive. The most persuasive would be the New Mexico case that just happened recently. When do you think New York will be done? That's a good question too. So we've got Ivanka coming up, and the thing with New York is that the AG's office doesn't really have that many more witnesses. We've got a few questions about whether or not their experts will be allowed in, but the state's witnesses are not that many left. So I would say they're definitely going to be done, I think, with their case in chief probably within the next couple of weeks. But then we've got, over 100 witnesses for the defense case in chief. So if she finishes up by the 17th, I wouldn't be surprised. But then they've got all of their witnesses to present, and it's supposed to end on the 22nd. So it will really be up to how quick Judge Engeron kind of gets the defense witnesses on and off. Because again, the state had 27 witnesses. The defense has 127 witnesses. If you write him in, even if he's removed from the ballot, your vote won't count. Right, exactly. I mean, you can write anybody in that you want. You can write in Mr. Goodbar. It doesn't matter. It doesn't mean Mr. Goodbar is qualified. Or you could write in somebody who was 30 years old. So say, Joe Bibbidi Bob, and he's, 30 and he's not old enough. You can still write him in. It doesn't mean that he's qualified. So that's really what the situation is. Case in chief means when it's your turn to go. So the state goes first in this civil case. So they present their entire case. So all of their own witnesses, all of their own evidence, and it's cross-examined by defense. And then when they're done presenting all of their evidence, that's their case in chief, and they rest. When they rest their case, defense goes next. They present all of their witnesses, all of their evidence. That is defense's case in chief, and then they rest. We can come back and do rebuttal after that, but that initial set of witnesses and evidence is called a case in chief. Should this get appealed and overturned, but 45 gets charged guilty in Georgia, would that then overturn? I don't know. I'm not sure that those are on the same track. I'm not sure that those lines would cross over. I think if he's convicted in Georgia, that will be a separate issue. I think whether or not he's on the ballot and continues to be on the ballot is Road A, and then the Georgia is Road B, and those are not going to intersect until after the election. In my opinion, I just don't think those two roads will cross. Yeah, I mean, it's interesting. Historically, it's a very interesting time for sure. When it comes to legally. Yeah, people voting for Kanye. Oh, yeah. I mean, you can vote for whomever you want. If the case was posed as same and Trump's motion included admission of false. Right. So are you saying if he pled out in Georgia, would that disqualify him? Is that what you're saying? Because I don't think so. I don't think anything he does in the Georgia case will impact what's happening with him being on the ballots under the 14th Amendment. In my opinion, those two things do not cross each other. They're on separate tracks. The criminal road versus this constitutional law question. I do not think that there's a crossover. Some people might say, well, it could show a conviction then of insurrection, but that, we're not even at that point yet, because those kinds of questions about what those terms mean is what's being debated. So whether or not there's a conviction or not, again, isn't going to really be relevant to how they're actually interpreting those words. He could technically win the presidency from a Georgia prison cell. Exactly, Rich. Yeah, that's exactly right. What's the strongest case against 45? So, in my opinion, and let me just grab my cases here real quick. All right, so in my opinion, the absolute strongest case by far, again, I'm not talking the civil case, just the criminal cases. The strongest case is the Florida case by far. This is the most open and shut case with the least amount to prove, the easiest case by far. It's very simple. Did he have the documents? Yes. Was he supposed to? No. Were they classified? Yes. We're done. That's it. This is the absolute strongest case. Will he go to jail on this case? I don't think so. Not with Judge Cannon. I don't think that she would sentence him to jail, but this is by far the strongest case and has a lot of jail time too. Again, we've got 32 counts, 10 years each. The potential for jail time is there. Will he actually get it? I don't think so. I don't think he will get a jail time, but it's by far the strongest case. Next, I would say, between DC and Georgia, it's a mixed bag. DC is good because he's the only defendant. So all of the focus is on him. You're not splitting resources between 18 other defendants like you are in Georgia. So you've got these 4 federal charges here, 1 defendant. That's pretty good. I mean, as far as keeping that focus on what you're supposed to be doing and also keeping the jury with you throughout the whole trial. In Georgia, though, their RICO statute is amazing. I mean, if you're going after a criminal enterprise, this is where you want to have it. You want to have it under the RICO statute. And then everyone who's involved in the conspiracy gets pulled in. And so all of them can be pulled in easily. We've already got 4 people that have flipped at this point. So we've already got strong evidence coming in. And we've also got the mandatory minimum 5 years. Georgia is the most likely to have prison actually. For if Trump's going to serve prison time, it'll be because of a conviction for the RICO case in Georgia, in my opinion. There's not much prison time in DC. We're not really looking at prison time. The biggest sanction here, of course, is going to be this conspiracy against rights, meaning he'll be convicted of trying to prevent people's right to vote. So I think the meaning behind the conviction will be the most in DC. Prison time, most likely in Georgia, if it's going to happen. Strongest case is Florida. Why is it too late for getting Judge Cannon removed from the trial? I don't think she's done anything that would constitute removal for her at this point. Technically, it really takes a lot to get a judge off of a case. And it's supposed to be that way so that, if you don't like how the judge is ruling on things, you can't just bump them off either way. We're seeing that for New York and we're seeing that in DC as well, which by the way, there is also the New York criminal case. I haven't included it here because it's fine, but it's really nothing to write home about in my opinion. But, I don't think Judge Chutkan's done anything that has risen to a level of her being disqualified at this point, technically under the rules for her. But I will be going through her reversal. The Court of Appeals did reverse her. And so I'll kind of be breaking that apart with everybody then on Thursday when I do a live then. And we'll kind of talk a little bit more about what the rules are for getting her pulled if we were going to do that. I do have the judicial conduct rules pulled, and so I will talk about that too. We'll kind of do a whole thing on what it is a judge needs to do or what someone needs to do in order for a judge to be pulled from a case. So I'll kind of incorporate all of that in with the Judge Cannon discussion when we get into that on Thursday, so we can talk about that further. Yeah, Judge Cannon in Florida. Right, sorry. Judge Cannon can't be, it's not at this point where she can be removed out of Florida. Judge Chutkan had a situation where they asked her to recuse herself. They already tried to pull her off the case, is what I was saying. They tried to pull her off the case. They tried to pull the New York judge off the case as well. So both of those judges they've already tried to pull them from the cases, is what I was saying. Judge Cannon, no one has tried to pull her yet. And I'm not sure she's risen to that level. Of course, Judge Chutkan said, no, I'm not going to recuse myself, as did the New York judge. So they both said, no, we're not going to pull ourselves off of these cases. That's what I was referring to on that. Yeah, so again, I don't know that she's done anything at this point that rises to it, but I will definitely be getting into all of the different pieces and all of the different elements. Right, right. So there were motions filed in DC and in New York for the judges to recuse themselves. But both of them said nope. Yeah, and Cannon has not been requested to remove herself. They've had all the other ones, but not her. And even in several civil cases, too, the defense has requested that the judges recuse themselves or that they're not qualified, that there's a personal vendetta. Of course, there's a huge lawsuit against the judge and Letitia James in New York as well, saying that Letitia was so biased, or that Miss James was so biased, and that she ran a campaign on getting Trump, and so it wasn't fair for him to have this civil case. And it got appealed and appealed and appealed, but it got knocked down, and it said she was fine. She could continue on. Yeah. So yeah, she's still here, and again, I don't see anything that's really risen to the level of her truly being pulled from the case. But I will be bringing in what the rules are, what the standard is for a judge to be removed out of a federal court, just so we can talk about that. Yeah, Cannon doesn't have enough experience. I think her inexperience shows. Judge Chutkin doesn't have a lot of experience, but she's much more polished. They just have different styles, but I think Judge Cannon is struggling a little bit, in my opinion. Yep, absolutely. Oh, absolutely. Everybody's got to vote. Everybody's got to vote. Yep, voting's very important. I don't care who you vote for, but just go and do it. Everybody needs to vote for sure. Voting is the key here. That's what we're all about. So that's it, everybody, for tonight. That was my 14th Amendment overview. I gave you real quick, kind of the quick and dirty version of that, and then kind of a quick overview here of the Trump cases and where they're at. We've got a lot going on this week in New York. Just a few motions, though, and those kinds of things happening for the other cases. I'll be interested to see what happens in Georgia. I'm still waiting for more flippers at this point. So I'm waiting. I'm patiently waiting for the flipping to continue on as we go. Yes, of course. You're most welcome. You're most welcome, everybody. I will be back again tomorrow, 7 o'clock Central Time. I was a little early tonight. It just kind of worked out that way. But I will be back tomorrow going over some motions, and I think we'll have that big brief in as well. And then we'll have multiple things going on for the rest of this week. So should be very fun, everybody. I hope you'll come back and join me again later this week. It's always great to hang out and see everybody. I will stay up to date as best as I can. So I will have this up on my Tube of You channel soon. I've got about 4 videos right now waiting to be uploaded, so those will be coming out. I can only put one up a day on YouTube, so I'm a little bit behind, but I will probably put this one up within the next day or two, just because it's an overview of what's coming on for this week. So have a great night, everybody. Yes, thank you so much for all of your participation and your questions. Thank you so much, and the moderators, of course, you're amazing. Appreciate that. So is there going to be a test? No. Nope, no tests. But have a wonderful, wonderful night, everyone. I'll go ahead and sign off now. But, and I will be back tomorrow, 7 o'clock. Have a great night. We'll see you again. Thanks again, moderators. You are all the best.